And in 9 charges leveled against me, this place where I committed this crime was London, in the United Kingdom. When my lawyers came to see me, I had a discussion with them about how I'm going to defend myself.
They removed it.
I told them that no court in Nigeria has jurisdiction to try me.
They removed that London.
Because since this offense was committed in England, so they said, it's only a UK court that can give a Nigerian court the authority to proceed, isn't it?
Yeah, based on that, they removed London.
Based on that, they now amended the charge again and removed London.
Location of the broadcast.
Location of the broadcast. Contrary to section 196,
174 of the Terrorism Prevention Act 2022.
in violation of their own laws. In violation of their own laws. And you want me to stand trial under such circumstances? Is that possible? Nnamdi Kanu to stand trial where these shenanigans are going on? It's not possible.
It's a persecution against the Igbos. It's a persecution
No, let them give them a fresh one, not the ones.
No. We have many of that.
Mr. Philip, last one last question. One last question. Reference to what she has asked earlier. One of the senior judges at this court.
And I have respect and love for her. She knows.
What if this case comes back to her? Because
It is not possible. It's not possible. This persecution of the Igbo people, this orchestrated, almost global persecution of the people, stops with me. It cannot happen.
Very well.
It can never happen. That is why we do what we do. That is why I do what I do. I am campaigning for the freedom of my people because of the persecution that we are facing.
Yes.
It's as simple as that. Nothing more, nothing less.
Yes.
Thank you very much.
The rules change when it comes to us.
Anybody standing in trial or coming to try me is a terrorist. That's what their law says. Section what me? As simple as that. Section 2, subsection 3F of Terrorism Prevention and Prohibition Act. That's what it says. Any court considered to try me is committed an act of terrorism. Yes. Very clear. You cannot violate a treaty that Nigeria entered into and then come to try that very person. Is not done anywhere in the world. So you must be aware of that. So that is why there is all these ridiculous delays. That is what Supreme Court said. I did not jump bail. My home was invaded. They came to kill me and I survived. They came to Kenya to kidnap me, brought me back to this country and seeking to try me, which the law says cannot happen. You cannot violate a treaty that Nigeria entered into and then hope to stand on that illegality to conduct a trial. Is not done anywhere in the world. And we have it in my case. Of the people stops with me. It cannot happen. It can never happen. That is why we do what we do. That is why I do what I do. I am campaigning for the freedom of my people because of the persecution that we are facing. It's as simple as that. Nothing more, nothing less.
Thank you very much.
So I was actually surprised that a high court have refused to obey or abide by the determination of a Supreme Court judgment.
And then take the only part that is against him and then refuse to apply the part that is in favor of him.
This cherry picking of what was contained in the Supreme Court judgment is what I'm against.
Yes, that's correct.
It should be implemented holistically.
Yes.
I'm not against taking any trial.
Judgment.
After I'm innocent, they have not been against me. But there cannot be any trial when key sections of the Constitution and a key Supreme Court judgment has been violated by a court of law.
So you'll be patient for the case to go back and come back to the court?
This is my 4th year in solitary confinement in detention. The 5th year will not kill me.
Sorry, what if the case is also reassigned back to her? Will you still be comfortable?
It's not going to happen.
No, it won't happen.
It won't happen. It doesn't happen.
It doesn't happen that way. It doesn't happen that way at all.
Thank you very much.
These are the things that the public must understand. Most of you journalists, the legal correspondents, you don't take time to actually study some of these rulings and judgments. Go and study. In fact, I'll give you...
Bring that envelope. Bring the envelope.
Look at it here. Look at it here. Look at it.
I'll give it to her because I think she's a bit more...
Give her the Supreme Court judgment.
Can you hold this for me?
She can...
I want to let the whole world understand something. Very, very clear. In all this is judgment of the Supreme Court. It made it very clear that even that the impartiality of the judge is questionable. And it's here. Where is it? Please do bear with me. It says it here.
I like
what is it, page? What is that again? where there is, all these things are online. Is it not page 18? All these things are online. So I suggest that the journalists in this country actually take out time to do some basic research. It's not difficult, just minor research. You will understand the virtuousness, the emptiness of all the charges against me. Okay. They kept switching the charges. Yes. They said I committed this crime in England, isn't it? Yes. I made a broadcast in England. Yes. And in 9 charges leveled against me, this place where I committed this crime was London, in the United Kingdom. Yes. When my lawyers came to see me, I had a discussion with them about how I'm going to defend myself. I told them that no court in Nigeria has jurisdiction to try me. Because since this offense was committed in England, so they said, it's only a UK court that can give a Nigerian court the authority to proceed, isn't it? Yeah, based on that, they now amended the charge again and removed London.
Location of the broadcast.
Location of the broadcast. Contrary to section 196?
174 of the Terrorism Prevention Act 2022.
In violation of their own laws. Violation of their own laws. And you want me to stand trial under such circumstances? Is that possible? Nnamdi Kanu to stand trial where all these shenanigans are going on? It's not possible. Because the Nigerian people without going to jail and suffering for them is normal. Then my primary concern is to stop insecurity. And it will stop. Once I come out, it will stop. And they know it. So those keeping me in detention are those that are either benefiting or profiting from this situation. That's all there is to it. Okay? What do you say? I didn't know. No problem.
Mazi, good morning.
How are you?
Fine, good to see you.
Good to see you too.
How are you doing?
Not very well.
What happened?
A lot of insecurity back home.
Okay, but health-wise, how are you doing?
Yeah, I'm surviving.
You're faring well?
I'm surviving.
Okay.
Not faring well, just surviving.
So, a quick question. The last time we were in court, you talked about out-of-court settlement. You wouldn't mind. So, has that made any progress towards that regard in terms of talking to the agent?
My lawyers have been a better person to actually tell you that.
But you've been able to meet with them after that particular day?
Have you dealt with this very issue?
No.
Which one?
It has to be after court. We can talk about that.
Okay. No,
we're here for the judicial.
No, what I was asking is, did they come to visit you after the proceedings the last day?
Absolutely. We're here for the judicial proceedings.
Yes. We're here for the...
we can address the other one.
We'll do that later.
And we have written a letter to them that they have not replied.
Okay, no problem.
They have not responded.
Yes, they have not responded. I met with Attorney General.
And mind you, the political solution was a solution actually suggested by the Supreme Court.
Okay.
Yeah. And then the judgment. And most of you journalists should take time to go through some of these judgments and then come to your own conclusions. Yes. Go through all the rulings and the judgments. You know we have no case to answer at all.
Very well.
Thank you very much.
Thank you. We're sticking to the plan.
Do you agree with his position?
Yes, with what happened in open court today, we tried our best as his legal team to advert the attention of the court, call the attention of the court to the infirmities in the proceedings, the constitutional infirmities, very serious, very grievous constitutional infirmities that are militating against preparing him for fair trial. In particular, the breach, the flagrant breach of Section 36, rights to fair hearing, which were not being properly addressed by the court. We wanted those infirmities to be removed, those features, those things that are making it impossible for this trial to proceed fairly to be removed before Carlo could be put to trial. But my lord, the court was very reluctant to do that, and the court was blinded by some reasons in its wisdom to proceed with trial when Mazi Kanu has not been given the opportunity with his counsel, team of counsel, to prepare him for this trial at detention facility, DSA detention facility. So we felt this is unconstitutional, but the court was blinding itself to that. So our client had no choice than to express himself. That is his constitutional right. And remember that historically the Supreme Court had questioned the impartiality of this very court. So today it appeared that the Supreme Court was right after all.
But if you look at what Justice Binta said, she said that the part of the judgment where Mr. Kanu anchored his decision or his outburst in court for her to recuse herself was a contributory judgment, not the lead judgment. That judgment was made by Justice Emmanuel Auge, and that is what he's basing his decision for her to recuse herself. So what is your take on that?
Well, she did not say that on the record. When we applied for restoration of the bail, we made the argument that this is part of the lead judgment. The opposing counsel made a contrary argument. She never made a ruling on that. She dodged the question. She never made a ruling. What she said in open court today was a surprise to us. The issue whether the judgment, that part of the judgment was an obiter dictum, or whether it was part of the lead judgment or whatever, they raised the issue for the prosecution. We addressed it. When she made her ruling, she dodged the issue. Rather, she went abroad to say that she had previously forfeited the bonds that protected the bail that he had given to him, and that forfeiture was a question before the Court of Appeal, which also was in error. So we went on appeal. If she had addressed this issue on the record that it wasn't part of the lead judgment, we would have taken it head on.
Okay, lastly, sir, remember your client always complained that he had health challenges, hearts, and thereafter. And now that the court has said that this case can be sent back to the CJ, don't you think it will take time? Because Justice Binta said that the CJ is unavoidably absent from the court. So the time before the court